Hello students, welcome to the lecture on Law of Sale of Goods, and after this lecture we will be able to learn the following objectives. Describe the meaning of contract of sale of goods. Explain the essentials of a contract of sale. Understand the formation of contract of sales. Discuss the doctrine of caveat emptor. Explain the provisions relating to transfer of property. Describe the rights of an unpaid seller against the goods. Let's start with the concept of law of sale of goods. Businesses as well as consumers are usually free to enter into contracts on whatever terms they see fit to agree. However, contracts involving sales of goods can be subject to a range of statutory provisions. Consumers have greater protection than buyers who are dealing in the course of a business. Let the buyer be aware of caveat emptor does not apply to all transactions, and anyone selling goods in the course of a business to consumers should be aware that the law will imply certain terms into all such transactions. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price. It thus includes both an actual sale and an agreement to sell which has been distinguished later. Goods means every kind of movable property other than actionable claims and money, and includes stocks and shares, growing crops, grass and things attached to or forming part of the land which are agreed to be served from land before sale or under for contract of sale. Let us now discuss the meaning of contract or sale of goods. Formal contract by which a seller agrees to sell and a buyer agrees to buy under certain terms and conditions spelled out in writing in the document signed by both parties. An invoice, for example, is a contract of sale, also called agreement of sale, contract for sale, sale agreement, or sale contract. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. There may be a contract of sale between one part owner and another. A contract of sale is a legal term including both sale and an agreement to sale. In sale, there are always two parties, that is, seller and buyer. According to Section 4 of the Act, sale means the transfer of goods from a seller to the buyer for a price. Where under a contract of sale, the property in goods is immediately transferred from the seller to the buyer. In agreement to sale, the transfer of a property in goods is to take place at a future date or subjected to the fulfillment of certain conditions. Sale of Goods Act 1979, UK, the United Kingdom Sale of Goods Act 1979, whose ancestor, the Sale of Goods Act 1893, is the father of Sale of Goods Act throughout the English-speaking world, defines contract of sale at sect.
Of Goods Act, year 1979.
This act refers to the process of the sales of goods between a supplier and the customer.
It means that all goods sold have to require being of a satisfactory quality and fit for purpose.
This means the product or goods have to meet the standard purpose in the product's description, as well as personal purpose, for example, selling a particular brand of shoes to an athlete.
It also refers to the selling of a good being sold to a consumer at a consideration called price.
Price of goods sold must satisfy both the supplier and the customer, therefore an agreement needs to be made.
Goods that automatically fall under this act are all tangible items that can be handled by both the supplier and consumer.
Therefore, if goods fail to meet the requirements presented on the packaging, etc., customers are entitled to claim under the Goods of Sales Act.
Now moving on to the next topic, we will study the essentials of a contract of sale. There should be two parties. There must be two parties, buyer and seller. Buyer means a person who buys or agrees to buy goods, and seller means a person who sells or agrees to sell goods. The seller and the buyer should be two different persons because a man cannot purchase his own goods. The parties should also be competent as per Indian Contract Act. There should be movable goods. There must be some goods. The goods which form the subject matter of the contract of sale must be movable. The term movable goods means every kind of movable property other than actionable claim and money, and includes a stock, that is shares, grows crops, grass and things attached to or forming part of the land which are agreed to be separated before sale or under the contract of sale. A specific description of the goods or services that will be provided under the contract, including the level of service if the contract is for services. This section should also include who is responsible for supporting and maintaining any products through the term of the contract. Term of contract. The length of the contract should be stated, and it should also be noted whether there are any options to continue the contract. Time scale. The specific time scale for the project should be noted, including any deadlines that have to be met. Limitation of liability. This section caps the liability of either party to the contract. For example, neither party shall have any liability to the other party for a claim of loss of profits. Confidentiality. Some contracts deal with commercially sensitive information, and the parties are likely to want to keep this information confidential. There should be confidentiality clauses drafted in the contract which identify the information being protected and the circumstances in which it can be used or disclosed. Indemnity. Indemnity clauses are an express obligation to compensate the indemnified party by making a money payment for some defined loss or damage. They provide for an immediate right to compensation without the need for a lengthy dispute as to the circumstances giving rise to the specified loss or damage. For this reason, careful attention should be given to the agreement of any indemnities. Let's know the formation of contract of sales. A contract is an agreement reached between two or more parties which are legally enforceable when executed in accordance with the specific requirements. Contracts should be project specific and reflect the agreement between the parties. Contracts are obviously a key part of every business, and it is therefore fundamental that all parties to a contract understand the terms included in a contract and the rights and responsibilities of the parties under that contract. Every contract should have offer, acceptance, consideration, and intention to create legal relations. Acceptance of an offer occurs when there is an unqualified acceptance of all the offer terms. However, this is unusual and there will normally be a period of negotiation. Communication of acceptance. A contract offer has been accepted when the acceptance was brought to the attention of the offer, or this applies in the case of instantaneous communication such as by telephone, where the party giving acceptance will often know at once if a communication is unsuccessful, so will have the opportunity of making a proper communication. Consideration. Consideration is the requirement of reciprocal obligations on the parties to a contract. Both parties must receive valuable consideration for performance of their side of the contract. Consideration is not required in Scotland, where donation is accepted in the law of contract. However, it is extremely unlikely that a commercial organization would provide goods or services for free. Terms of contract. Contracts can be in writing, made orally, or created through the actings of the parties. For clarity, most commercial contracts are in writing to maintain a proper record of the agreement. Oral contracts create a greater potential for disputes on the terms, with the parties having problems evidencing their position. Contracts can be formed through a course of dealing between the parties. Again, the terms and conditions may not be clear. Common terms are likely to be incorporated in these contracts, but if they are not written down, there are still evidential problems. It is common for contracts to be on a company's standard terms and conditions. Problems can arise when both parties purport to contract on their own standard terms and conditions. Qualified acceptance of an offer while imposing own standard terms and conditions are seen as a counteroffer. Obviously, being unaware of which terms and conditions the parties are contracting does not provide the desired clarity or certainty of the contract. Doctrine of caveat emptor. The term caveat emptor means the buyer beware. It means the person who buys goods must keep his eyes open, his mind active and cautious while buying the goods. As a general rule, the buyer purchases goods after satisfying himself as to quality and fitness, and therefore buyer purchases the goods at his own risk and relying upon his own skill and judgment. In a contract of sale of goods, there is no implied warranty or condition as to quality or fitness for any particular purpose of goods. Therefore, buyer purchases goods at his risk, and if he makes a bad choice, he cannot blame anybody. Exception to the rule. Implied condition as to quality or fitness, when buyer relies entirely upon the judgment and skill of the seller. Customs or usage of trade. When buyer purchases goods as per customs and trade, then implied warranty and condition as to quality and fitness is there. Example, buyer demand camel ink. Fraud. When seller is guilty of fraud, seller is liable. Mercantile quality. Goods are mercantile if they are fit for any one of the several purposes for which the goods may ordinarily be used. For example, a bottle shall not break while opening the cork. Provisions relating to transfer of property. Transfer of property in goods is distinct from delivery of goods. Property or ownership may pass to the buyer without delivery of the goods, while delivery of goods may not constitute transfer of ownership in the goods. Transfer of title. The general rule is that it is only the owner of the goods who can sell them. A person who is not the owner of the goods cannot make the other person owner of those goods by selling them to him. This principle is expressed by the maximum nemo dat quod non habet, that is, no one can give what himself has not, that is, a seller cannot transfer a better title to the goods to the buyer that he himself has in goods. The rule is meant for the protection of the owner so that the persons such as thieves, finder of goods, public auctioneers selling without the seller's consent, or person who sell them to other, that is, the defense of the buyer that the buyer was completely ignorant of the fact that the seller was not the owner of goods is not at all tenable against the true owner of the goods. Exception to the rule. The above rule, that is, no one can give better title to goods than he himself has, is however subject to certain exception. The rule is relaxed in favor of certain persons, that is, they can transfer a better title to the goods in the following circumstances, though they are not the true owners of the goods. Sale by mercantile agent. Mercantile agent has authority whether to sell goods or to consign goods for sale, or to buy goods, or to raise money on the security of goods in the customary course of business. A mercantile agent can sell the goods of the owner. A good title shall pass to the buyer. Essentials. The agent is in possession of goods or of the documents of the title to the goods. He is in possession of goods as a mercantile agent. Agent sells the goods in ordinary course of business. Buyer acts in good faith. Buyer has no notice that the agent has no authority to sell. Sale of goods by a person in possession of goods under a voidable contract. If a person has obtained the possession of goods under a voidable contract, that is, by fraud, coercion, misrepresentation, undue influence, and the contract has not been cancelled, he can pass a good title to goods to the buyer if the buyer buys them from the seller in good faith for value, that is, without having any notice of the defective title of the seller. Sale by a seller in possession after sale, where a person having sold goods but is in possession of said goods or documents of goods after the sale again sells, pledges, mortgages, or disposes them to any other person. Buyer gets a good title if he receives goods in good faith, that is, without notice of previous sale. Difference between transfer of property, ownership and possession. Following are the 15 differences between ownership and possession. Ownership. The idea of ownership follows the idea of possession. The ownership is the de jure recognition of the right over the property. Ownership is the subjective and objective. It signifies the externally and internally. The right of alienation is an essential characteristic feature of ownership. The concept of ownership is used in widest meaning. The ownership has the right to consume, destroy and alienate with his free will. The residuary power is vested in the owner. Ownership is the guarantee of the law. Possession. First, the idea of possession came into existence in the human civilization. Possession is the de facto exercise of a claim over the property. Possession is the objective realization of ownership. It is the external significance of ownership. This right is not seen in possession. The concept of possession is narrower in this sense. The possession has limited rights to consume, destroy and alienate. Performance of sale of goods contract. When goods are sold, a sale of goods contract is created. Within that contract, different duties are imposed on the parties to it, that is, the seller and the buyer. If any of the parties fails to carry out his or her duties under the terms of the contract, such omission attracts adverse consequences. The performance of a sale of goods contract has 3 dimensions. These are evident in the provision of Section 27 of the Sale of Goods Act 1893, which provides that it is the duty of the seller to deliver the goods and that the buyer is to accept and pay for them, in accordance with the contract of sale. Acceptance of the goods by the buyer. The buyer is obligated to accept the goods when they are delivered. In this context, acceptance involves the buyer taking possession of the goods. This may be by express statement. If the buyer refuses to take delivery of the goods at the stipulated time, that does not automatically permit the seller to selling off the goods to another person unless the delay of the buyer in taking delivery of the goods is unreasonable. Any unpaid seller has twofold rights: rights of unpaid seller against the goods and rights of unpaid seller against the buyer personally. We shall now examine these rights in detail. Rights of unpaid seller against the goods. An unpaid seller has the following rights against the goods, notwithstanding the fact that the property in the goods has passed to the buyer. Right of lion. Right of stoppage of goods in transit. Right of lion, Section 47. Lion is the right to retain possession of goods and refuse to deliver them to the buyer until the price due in respect of them is paid or tendered. In the case of buyer's insolvency, the lion exists even though goods had been sold on credit and the period of credit has not yet expired. When the goods are sold on the credit, the presumption is that the buyer shall keep his credit good. If therefore, before payment the buyer becomes insolvent, the seller is entitled to exercise this right and hold the goods as security for the price. The unpaid seller's lion is a possessory lion, that is, the lion can be exercised as long as the seller remains in possession of the goods. Where the property and goods has not passed to the buyer, the unpaid seller has, in addition to his other remedies, a right of withholding delivery similar to and coextensive with his rights of lien and stoppage in transit where the property has passed to the buyer. This right of lien can be exercised only for the non-payment of the price and not for any other charges, that is, maintenance or custody charges which the seller may have to incur for storing the goods in exercise of his lien for the price. This right of lien extends to the whole of the goods in his possession, even though part payment for those goods has already been made. Right of stoppage of goods in transit. Meaning of right of stoppage in goods in transit. The right of stoppage in transit means the right of stopping the goods while they are in transit to regain possession and to retain them till the full price is paid. The essential feature of stoppage in transit is that the goods should be made in the possession of a middleman or some other person intervening between the vendor who has parted with and the purchaser who has not received them. Now in the end, let us summarize what we have learnt in this lecture. The contract of sale of goods is a broader term that includes sale and an agreement to sell. A contract of sale is made by an offer to buy or sell goods for a price and the acceptance of such offer. The terms agreed are put in writing in the form of an agreement, which is known as agreement to sell. Transfer of Property Act makes it mandatory to produce the documents for scrutiny. Possession isn't the most important ingredient of the sale transaction. The transfer of property in the goods form, the seller to the buyer, is the essence of a contract of sale. Actual delivery means physical transfer of goods by the seller to the buyer.